Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability.
6A, subsection 3 seems to have been to pacify the apprehension of the people of Assam that conferment of citizenship would not have an immediate impact on the then upcoming elections in the state of Assam due to the inclusion of a large number of immigrants. The apprehension was taken care of by the scheme of section 6A subsection 3, which provides for the removal of the immigrants belonging to the 1966-1771 stream from the electoral rolls for a period of 10 years from the date of their detection. Section 6A subsection 3 embodies the approach of the government of the day in finding a middle ground between two competing interests prevailing at that time. On one hand, adopting a humanitarian approach towards the immigrant population in Assam, and on the other, ensuring that large-scale immigration doesn't result into the loss of culture, economy, and the political rights of the people of Assam. While construing the object of enactment of Section 6A, one should not lose sight of an important fact, that Section 6A was enacted to give a statutory avatar to certain clauses of the Assam Accord. The provision thus could be said to have been multifaceted in design and purpose and representative of the interests of all the parties to the negotiation. I am of the view that the intention of the parties while signing the accord should be kept in mind while construing the object of Section 6A of the Citizenship Act. Then I have said on whether the onus of detection of foreigners of the 1966-71 stream lies on the state. From a perusal of Section 6A and the associated rules, it is clear that there is no provision which prescribes or provides for self-declaration/registration or voluntary detection as a foreigner within a given time period for availing the benefit of citizenship by registration under Section 6A subsection 3. The mechanism of implementation of Section 6A is set into motion with the first step of reference of a suspected foreigner to the foreigners tribunal. As soon as a reference is made to the tribunal, the onus is on the suspected person to either establish that he or she is an Indian citizen or to establish that he or she is an immigrant eligible to avail the benefit available under Section 6A. Once the tribunal holds that the suspected person is a foreigner of the 1966-71 stream of immigrants, then again the onus is on the said person to get registered in accordance with the Citizenship Rules 2009, failing which his or her claim to citizenship would abate. While the statute is clear that the onus completely shifts on the suspected foreigner once a reference is made to the tribunal, it appears to me as illogically unique that a person wanting to avail the benefit of citizenship by registration under Section 6A subsection 3 has to await identification as a suspicious immigrant and subsequent reference to the tribunal. There is no plausible reason why it should be impermissible for him or her to set the mechanism of Section 6A into motion by voluntarily choosing to get detected as a foreigner of the class specified in Section 6A or to make an application for conferment of citizenship. Further, what stands out as palpably rational in the scheme of Section 6A of the Citizenship Act is that there is no end date after which the benefit of citizenship under Section 6A subsection 3 cannot be availed. I have dealt in later parts of this judgment as to how this militates against the very purpose of the enactment of Section 6 capital A subsection 3. I have now said something on temporal reasonableness. Neither Section 6A nor the rules made thereunder prescribe any outer limit for the completion of detection of all such persons who belong to the 1966-71 stream and are eligible to avail the benefits of Section 6A, subsection 3. The clock only starts to tick once the detection is made by the foreigners tribunal, and there is no prescription as to the period of time within which the exercise of discrete detection is to be completed from the commencement of Section 6A. The absence of any prescribed time limit for detection of foreigners of the 1966-71 stream has twofold adverse consequences. First, it relieves the state from the burden of effectively identifying, detecting, and deleting from the electoral rolls in accordance with law all immigrants of the 1966-71 stream. Secondly, it insensitizes the immigrants belonging to the 1966-71 stream to continue to remain on the electoral rolls for an indefinite period and only get themselves registered under Section 6A once detected by a competent tribunal. Hence, the manner in which the provision is worded counterserves the very purpose of its enactment, which is the speedy and effective identification of foreigners of the 1966-71 stream, their deletion from the electoral rolls, registration with the registering authority, and conferring of regular citizenship. As submitted on behalf of the petitioners, the open-ended nature of Section 6A, subsection 3 also subserves the legislative intent behind the enactment of the IEAA 1950 and the spirit of the Assam Accord. In the absence of any statutory mandate to do so within a time limit, and there being no temporal limit to the applicability of Section 6A, subsection 3, it follows that any immigrant of the 1966-71 stream whose name figures in the electoral rolls would not voluntarily want to get detected as a foreigner, as upon detection, such immigrant becomes liable to having his or her name struck off from the electoral rolls. It is also required to register with the registering authority within a specified time period, failing which he or she would become liable to deportation. Even otherwise, no person belonging to the aforesaid category would, out of their own volition, get detected as a foreigner due to the inherent subjectivity that is involved in the process of scrutiny and determination of the various conditions as stipulated under Section 6A, subsection 3, that is, date of entry into Assam, ordinarily resident, etc. However, the same degree of reluctance would not have been present on part of the immigrants of the said category if the procedure of conferment of citizenship under Section 6A, subsection 3 was instead a one-time exercise, which was to be mandatorily undertaken in a time-bound manner by anyone who wished to avail the benefit of citizenship under the said provision, and any failure to abide by such time-bound procedure would have resulted into the abatement of their claim to citizenship. Seen thus, the working mechanism of Section 6A, subsection 3 goes against its avowed objective. Upon perusal of the statutory scheme under the Citizenship Act, the Foreigners Act 1946, and other related provisions, it could be seen that the mechanism prescribed for giving effect to Section 6A is imbued with the idea of temporal limitations, and in the absence of temporal limits on the period during which 6A is made applicable, the provision counterserves the object it was enacted with. It could be argued that the principle of temporal unreasonableness cannot be made applicable to a situation where the classification still remains relevant to the object sought to be achieved by the provision. However, as discussed in the foregoing paragraphs, the underlying object behind the creation of two distinct categories.
Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability.
Two distinct categories of immigrants under Section 6A of the Citizenship Act could have been achieved only if the exercise of detection of the immigrants of the 1966-71 stream and their deletion from the electoral rolls was conducted in an en masse and time-bound manner. However, the same having not been achieved as intended, I find no justification to hold that the classification made between the immigrants of the pre-1966 and 1966-71 streams still remains relevant to the object of Section 6A. To allow Section 6A to continue indefinitely for all times to come would tend to amount to taking a reductive and one-sided view of the historical context in which Section 6A came to be enacted, more particularly that Section 6A sought to achieve a delicate balance between two competing interests. In the last, on manifest arbitrariness vis-a-vis temporal unreasonableness, I have said, from a perusal of the scheme of Section 6A, subsection 3, it is evident that the procedure prescribed therein leaves the possibility of differential application on similarly situated persons wide open. From any view of the matter, the way in which the provision is worded doesn't effectively serve either the purpose of granting citizenship to the immigrants belonging to the 1966-71 category, nor does it effectively serve the object of the expeditious deletion of the same category of immigrants from the electoral rolls. On the contrary, as discussed in the foregoing paragraphs, Section 6A, in the absence of any temporal limit to its application with the afflux of time, is rather counter-serving the object with which it was enacted. The mechanism doesn't permit an immigrant of the 1966-71 stream to voluntarily seek citizenship, and such an immigrant has to wait indefinitely for a reference to be made to the Foreigners Tribunal. Similarly, in the absence of any specified date for availing the benefit of citizenship under Section 6A, subsection 3, the object of expeditious deletion of immigrants from the electoral roll is not met. While the test of manifest arbitrariness entails a two-pronged test, which requires that first, there is a reasonable classification based on an intelligible differentia, and secondly, that such classification has a rational nexus with the object sought to be achieved by such classification. The test of temporal unreasonableness, on the other hand, would involve a further examination into whether the aforesaid two-pronged have continued to remain relevant with the passage of time. Thus, the test of temporal unreasonableness would require examining the provision in two different time frames. First, when the provision was enacted, and secondly, when such provision comes to be challenged on the ground of temporal unreasonableness. Even if a provision passes the two-pronged test in the first time frame, it may still fail the test in the subsequent time frame if the afflux of time renders either the classification or the object sought to be achieved by such classification, or both, as arbitrary and thus violative of Article 14 of the Constitution. This could be said to be the third prong in the test of manifest arbitrariness under Article 14, as envisaged by the doctrine of temporal unreasonableness. The conclusion. Section 6A has acquired unconstitutionality with the afflux of time. The afflux of time has brought to light the element of manifest arbitrariness in the scheme of Section 6A, subsection 3, which fails to provide a temporal limit to its applicability. The prescribed mechanism shifts the burden of detection of a foreigner solely on the state, thus counter-serving the very purpose for which the provision was enacted, that is, the expedient detection of immigrants belonging to the 1966-71 stream, their deletion from the electoral rolls, and conferment of de jure citizenship only upon the expiry of 10 years. My learned brother, Justice Suryakant, has acknowledged the fact that despite the enactment of Section 6A, the influx of illegal immigrants into the state of Assam did not abate after 1985. My brother has relied upon the report published by the then governor of Assam in 1998 to underscore that there are hordes of immigrants who have illegally entered Assam and are residing there. However, the ultimate view taken by my lord is that such illegal immigration cannot be attributed to Section 6A, which is limited in its ambit and does not by itself create unabated immigration. As discussed earlier, Section 6A, owing to its inherent problems of absence of temporal limit and the sole onus of detection upon the state, has indeed resulted in the influx and continued presence of illegal immigrants in the state of Assam to this date. On another issue on which I would like to respectfully disagree with my learned brother, Justice Suryakant, pertains to the fundamental premise that Section 6A aligns with the fundamental purpose of Articles 6 and 7 respectively of the Constitution. That is, Section 6A also confers citizenship rights on those affected by the partition of India. However, a careful perusal of Section 6A vis-a-vis Articles 6 and 7 respectively would reveal that despite a few similarities between the two, the crucial difference lies in the fact that in Article 6, the onus of registration for a person seeking citizenship lies on that person and not on the state. Additionally, all those persons who migrated to India from Pakistan after 19th of July 1948 had to make an application before the commencement of the Constitution. The permit system, which was introduced as per Article 7, was also brought to an end in 1952, as discussed in the foregoing paragraphs. However, as discussed, both these conditions, that is, the onus of registration as well as the specification of a cutoff date till which such applications could have been made, are absent from the very scheme of Section 6A. Seen in the context of temporal unreasonableness, this glaring absence renders the scheme of Section 6 capital A arbitrary and as a result unconstitutional. For all the foregoing reasons, I have reached to the conclusion that Section 6A of the Citizenship Act deserves to be declared invalid with prospective effect, and the same is accordingly declared so. I summarize my final conclusions as follows. A. Immigrants who migrated before 1/1/1966 and were conferred deemed citizenship on the date of commencement of Section 6A subsection 2, subject to fulfillment of all the conditions mentioned therein, shall remain unaffected. B. Immigrants who migrated between 1/1/1966 and 24/3/1971, both inclusive, and have been granted citizenship after following the due procedure prescribed under Section 6A subsection 3 shall remain unaffected. C. Immigrants who migrated between 1/1/1966 and 24/3/1971, both inclusive, and who have been detected as foreigners and have registered themselves with the registering authority as per the prescribed rules, shall be deemed to be citizens of India for all purposes from the date of expiry of a period of 10 years from the date on which they were detected as foreigners. D. Immigrants who migrated between 1/1/1966 and 24/3/1971, both inclusive, and who have been detected as foreigners but have not registered themselves with the registering authority within the prescribed time limit as per the Citizenship Rules 2009 will no longer be eligible for the benefit of citizenship. E. Immigrants who migrated between 1/1/1966 and 24/3/1971, both inclusive, and whose applications are pending for adjudication before the Foreigners Tribunal, or who have preferred any appeal against any order of such tribunal, which is pending before any court, will continue to be governed by Section 6A, subsection 3, as it stood immediately prior to the pronouncement of this judgment, till their appeals are disposed of. And last, F. From the date of pronouncement of this judgment, all immigrants in the state of Assam shall be dealt with in accordance with the applicable laws, and no benefit under Section 6A shall be available to any such immigrant. To be precise, if someone is apprehended as an illegal immigrant after the pronouncement of this judgment, Section 6, capital A of the Citizenship Act will have no application. This is my humble opinion. Thank you very much to all the learned counsel who rendered valuable assistance. My two law clerks, their assistance has been very valuable. And in the last, above all, I am beholden to my Lord, the Chief Justice, for this opportunity. Grateful to all of you.
Grateful to the court.
Thank you. And let's join my learned brother Jason Pardiwala and thank all of you for this amazing assistance which you got in the matter. Thank you very much.
Grateful.